August day in Brisbane. It is stunning outside, but we're here delivering the webinar. I'm Chris, I'm Strata consultant, former Commissioner, Body Corporate and Community Management. With me, as always, Frank Higginson, partner, Hynes Legal. Frank, welcome.
Hello, Chris. Hello, everyone. And I'm wearing flannel because I'm cold inside.
It's a bit fresh out there.
Beautiful, but cool.
Lovely, yes. As always, you can chuck a comment or a question live, and we'll try and get to all of those today, or even after the event for that matter. If you do have a bit more of an involved question, we're just about to put a link up there. If you could put your details in that, that's probably a better way of getting us the more detailed questions. That link's now up there. Today, though, Frank, the end. We have reached the end.
We've reached the end.
The end of Strata schemes, that is. Not the end of webinars, but no, the end. Ending a Strata scheme, finality, termination, as it is called. It's a big deal, isn't it, Frank?
It is a big deal. You know, it's a big deal in terms of what the government grapples with. And I think, interesting, this is a genuinely viewer-prompted webinar where this, can you talk about this? Yes, we can, because it's actually topical. And I suppose we get this question pretty regularly, particularly sort of obviously people scouting around online at night or after hours, you know, get the inquiry for the next day, is about a body corporate bringing itself to an end. And I think the very first, mate, it's a bit myth busting, Chris. We haven't done one of those in theory for a little while. The reality is, and here's the first rule that everyone seems to get wrong, body corporates cannot vote themselves out of existence on their own. So a body corporate can't resolve without all owners agreeing to terminate itself. And we get that a lot. Yeah, and I suppose part of it is what happened in New South Wales, which you haven't got there, and we'll get into that detail. But yeah, that's the first rule. Nothing happens unless every owner agrees or it's ordered some other way.
That's right, and you're right, Frank. That question comes up a lot. It comes up used to come up in the Commissioner's office quite a bit. So therefore, I'm assuming it still does. And we were just talking before we came on air, and I think sometimes the issue of termination gets used, unfortunately, as a bit of a battering ram, doesn't it? And a bit of leverage and a bit of a threat in some situations. It's like, oh, you know, we're going to do this, and this is going to happen, and you'll be out on the streets, and it's not like that at all. So today we're going to try and clarify a few myths on that point. So I think we've come up, Frank, with the idea that when we talk about terminating a scheme, ending a strata scheme, there are usually two main reasons for doing so, aren't there?
Yep, absolutely. Everyone's signed, and so the way it works at the moment, everyone has signed a contract to sell, usually to a developer, because your unit's on a site that's attractive. And done that individually, not via the body corporate. So if Chris owns a lot and Frank owns a lot, we've got to sign our own separate contracts with the developer, which Chris won't see mine and I won't see his unless we actually choose to share them with each other. And at that stage, what happens at the end of the day is the developer then owns all of the lots. And so they're in control of voting about what happens. And at that stage, the body corporate can collapse itself. And even, mate, this week, as much as we don't do conveyancing, this is, I suppose, a lot of work we did pre-GFC on the Gold Coast before we were based in Brisbane. There's lots of scheme amalgamations going on then, so we helped lots of clients individually through that. Not that we do conveyancing anymore, but I literally had a teleconference with a client or a Teams meeting with a client yesterday afternoon who has received an offer, and we're helping them negotiate it to get the best outcome for them.
So I guess that's the financial incentive reason. Well, I mean, it's all financial, but that's like the positive, if you like, financial incentive. And then there's the flip side of that, isn't there, Frank, where things at the scheme have become, frankly, not cost effective any longer to keep it going.
Almost where the building's a write-off.
Yeah.
You know what I mean? And it's probably particularly in coastal areas. I mean, concrete cancer, you know, Rio steel in buildings that gets exposed to salt spray over decades, tends to rust away and all that sort of stuff. So asbestos, electrical wiring, all sorts of things can go into it. So bodies corporates, being creatures of statute, have statutory obligation to keep common property in good repair and condition and maintain it. So they can't ignore problems. So if there's special levies to be struck, then that's what's got to happen. So that's the other one. So it's really, I suppose, in terms of the reasons why you'd consider this, you've got someone wanting to buy the whole site, or the building has got to the stage where it is going to cost more to maintain than it is to, I suppose, get rid of it. It's not worth the continued investment.
That's right. That's right. And look, within that, there are all sorts of variations about the termination, the reasons for it, and the particular circumstances. But they're the two main circumstances under which a scheme gets terminated. Where a lot of the problem usually arises is scheme termination where everybody does not agree. So as you said at the start, Frank, it's if everyone agrees, potentially happy days, but where everybody doesn't agree, and this is the issue that government in particular has to grapple with. I'm going to get in the latter part of today about that particular issue and why it's a particular problem for government. But before we get there, let's myth bust once and for all how things currently are at the moment. So a scheme may be terminated by resolution without dissent, provided there is an agreement about termination issues. And that's actually defined under legislation, Frank, isn't it?
It is, which is an agreement between all registered owners and every lessee in relation to the property. So in that sense, yes, the body corporate's involved in the resolution to terminate. So a resolution without dissent is a vote in which no one votes against the resolution, but it doesn't mean that everyone's for it, which is a really important distinction. So in theory, a resolution without dissent in a 100-unit building could be passed by one person voting in favour of it, none against. That's without dissent. The saving grace I mentioned before, a body corporate can't vote to, voluntary assisted dying laws for strata, Chris. A body corporate can't vote itself out of existence because as Chris said before, there's that resolution, but there's also a condition of that happening is that there is an agreement between every single owner about what's going to happen, which means that all owners, regardless of what the body corporate do, need to sign on to that arrangement. End of story. So no one can be dispossessed. And I suppose, you're almost at a fundamental issue, Chris, about property law, and you always go back to the castle. It's the vibe. It's your property, and at the moment, really, the only way to be dispossessed of it, other than by some form of resumption by government, for rail, road, whatever it might be, is if you agree to it. And that's the issue government's grappling with in terms of on what basis should we allow the majority to force the minority out of a property that they don't want to go.
So just up now, we've put that definition of termination issues. We had to put it in two parts because of the character limit. That comes from Schedule 6 of the Act. So that's the definition that's up there. So that's the resolution without dissent that you were just talking about, Frank. And then the second one, an order of the district court.
Yep. If the district court satisfied that it's just and equitable in the circumstances to terminate the scheme. So again, we're back to that, I suppose, that phrase that's consistently used throughout the BCCM Act in relation to adjudications, what's just and equitable. So when you're coming back to, and we have advised clients on a few of these matters over time, and to me, getting to what's just and equitable absolutely takes into account some personal circumstances, but also really takes into account those financial obligations that owners are going to have in relation to the building and whether it's still worth continued investment in. So, and it is a real issue. I mean, Strata, we had, I suppose, BUGTA, Building Industry Group Titles Act, arrive in 1980. So that is 41 years ago, when it was sort of recognised that there's enough of these strata things lurking around that we need a piece of legislation for it. So we've got buildings that were built under that 40 odd years ago that are potentially coming to the end of their natural lives. So this is the real issue that government's grappling with at the moment. But at the moment, we've got resolution without dissent and agreement from all owners, or we've got that district court order that's just and equitable. Now, to the best of my knowledge, I definitely know one of them, and I'm pretty sure the other one. There's two of these that really have been litigated, and both of them in the district court were resolved by consent. So what that meant is at the start of the matter, the parties were in furious disagreement. around what was going to happen.
Yeah.
And one person or entity brought the claim against the others to say, hey, we want an order from the court that this should be wound up. And the court didn't actually get to the stage of having to make a decision about what was just and equitable. So in a sense, we're still relatively in the dark about what these provisions actually would look like when a judge has to decide them.
Which actually also might help explain why government continues to grapple, because they don't have a benchmark to deal with at the moment. So that would also be part of it. Important to clarify that the only parties who can apply to the district court are the body corporate, a lot owner, or if there's an administrator for the scheme. And you can actually see how it would be quite feasible for an administrator to apply under those circumstances. If you do go to the district court, you're not obliged to have gone through that resolution without dissent process, but you would think it would make sense that you've gone through some kind of process within the scheme beforehand.
It's interesting, that one, isn't it? Like, you know, before you can commence a Commissioner's Office application, you've got to try self-resolution. There doesn't appear to be that same obligation in relation to commencing a court proceeding. You can just charge on and do it. But certainly, I think...
But Frank, just on that point, you would think if it got to that stage, you'd be hard-pressed to see how the judge in the district court would not be asking that kind of question, wouldn't you?
Absolutely, you would think. The first thing you're going to be saying is, well, I can't get it there.
Yeah.
And this is why, and this is what I've done to try to do it.
Yeah.
And then I suppose where courts tend to go with those things is it becomes an issue in relation to costs. So if you've charged on without trying to sort it out yourself and then you lose, then it's not going to be real pretty from a cost perspective. Because in court systems, as opposed to the Commissioner's Office and QCAT, costs usually follow the event. The loser gets to wear them.
Yep.
So it's different in QCAT, and in the Commissioner's Office, it's a no-cost jurisdiction at all. Or our $2,000 penalty, which is effectively no cost.
Nothing. Yeah. But I mean, that's it. So okay, so let's assume that you've gotten your termination either by the district court route or the resolution without dissent process. So what happens then? I hear you ask. Well, the scheme gets terminated. The title to all of the lots gets cancelled at that point. The body corporate gets dissolved. And I'll just read you out this bit. The assets and liabilities of the scheme are vested in the owners of the former lots as tenant in common in shares proportion to their respective interest schedule lot entitlements. Phew.
It's
another way of thinking of it, Frank, is that gets dissolved and proceeds divvied up in proportion according to your share.
Yeah, the assets, absolutely. You're then recorded on the title. So it gets really messy then in the sense of mortgagees. Because banks, and this is one of the issues in terms of getting a resolution without dissent in the lot owners agreement, is, you know, most people have mortgages, some lucky ones don't. So how are mortgagees protected when it comes to dissolving a body corporate? Because what they usually want is a separate indefeasible title over which they can exercise power of sale if their mortgage isn't met. When, you know, we had a 2-lot scheme. Chris and I own a lot each, where our contributions, our interest schedule lot entitlements are equal, 50-50. So what happens is that the property, if it's dissolved, is Chris Hynes, Frank Higginson, tenant in common, 50-50. What tenant in common means is that if one of us dies, that part of our estate is dealt with in accordance with our will, which is different from a joint tenancy. If Chris and I owned a property as joint tenants and one of us died, the deceased's interest vests with the other one automatically by virtue of property ownership, irrespective of the will. So tenancy in common is separate ownership. But if Chris is mortgaged with Westpac and I'm mortgaged with NAB, the banks don't like having a mortgage over a half share of a property as a tenant in common.
Yeah.
Makes it really hard for them, which is difficult then in terms of that lot owners agreement, because the mortgagee is going to be registered on the title to every lot. So, and again, and probably the other thing is that interest schedule lot entitlement, because everyone probably focuses on contribution schedules because that's your proportionate share of the levies. Interest schedule is your proportionate share of the value of the common property in the event of the dissolution of the body corporate, which is exactly what we're talking about today.
Yep.
And how would you sell it? How do you sell 1/50th of a title?
Exactly.
Really hard.
So we are talking theoretical to some extent, but anyway, this is the process that we have at the moment. As Frank said before, we're aware of probably 2 of these having been successful in the district court. And we also are aware of resolution without dissent in a couple of other cases as well.
And I suppose I'm going to do another GFC story, pre-GFC story, show my age. Jewel, the site that Jewel is on at the moment, that was at one stage we were acting for a few people selling out in there, one of which was the owner of one of the management rights in that scheme. There was 122 separate deals by my calculation that the developer had to do to put that site together, which is a lot.
Yep.
You know, so thus far, the only way these really happen is via that, and that is a function of money.
The market. It's always about the market. So look, I mean, I think it's probably almost weekly, maybe a bit more, that you or I, Frank, we hear from somebody either directly or indirectly or at an event, somebody say, oh, I'd heard that the law, or has the law changed now so that it's 75%. Sometimes people say 80%, sometimes people say 60, sometimes people say 70. And usually when people ask the question, they're asking it because they're actually a bit anxious about it. They're a bit upset because they think they're going to be turfed out or being left out. So usually it comes from a place of concern that they ask the question. So it happens a lot. So just rest assured that what Frank and I have just spoken about remains the law, hasn't changed. That's how it is. I think the reason why people get anxious is because some different thresholds have been talked about a lot and for a long time, and other states have changed things, other countries have changed things. The 75% issue, I think, comes from New South Wales, Frank. I think a lot of people assume because New South Wales went down that path, and again, it's not strictly 75% black and white. There's a whole lot that goes with it. But I think because that figure has come from New South Wales, I think Singapore, it's 70 or 80%, if memory serves me correctly. I can't quite recall. So I think because those figures get bandied about, people tend to imagine that that's how it is here, but it's not at the moment. So what?
And I suppose the other one is corporations law is 90%. You get to 90% of the shares of a company, you can force the other 10% to sell at the offer you've made to everyone else. That's sort of compulsory acquisition at that stage. So there's all those sort of thresholds that float around that to a degree have parallels with what we're talking about, but it has not happened in Queensland yet.
No. So what has happened is that there's been a property law review conducted by Queensland University of Technology, and they have made various recommendations, some of which have already been taken up in some areas, some of which are still floating around. Frank and I are both involved in the floating around process going on at the moment, and we'll get to that in just a second. Just about to put a link up here for you about where QUT recommended things would be at. It's a pretty wordy summary. I'm not going to read you out the whole thing. I think it's best to have a look at the link that's up there. But in summary, Frank, it's about something called a termination plan, isn't it?
It is. So really, and for me, the big thing with this when it first came out is, and the big difference between Queensland and New South Wales to date is that in New South Wales, they got to that 75% threshold and it happened, regardless of anything else. In Queensland, what QUT had come up with is that you can go down this process, but there needs to be an economic reason for it to happen. Now, of course, that's very wide gambit, but it's not forcing people out unless really there's a financial incentive to do so. So the way I read that at the time is that the financial incentive might be a whopping upside in terms of a buyout price from a developer. Yep. It also might be a whopping financial downside in the context of the repairs, that write-off example we used before, that the building might need, $3 million spent on it, and there's only 4 lots in there, and it's better just to sell the whole thing and be done with it. So, so the way QUT ran it or proposed was that there needed to be a termination plan put together, which is really by what was going to be a new breed of expert, someone, termination expert to take into account all of the things that need to happen, that go up to general meeting by resolution without dissent. So this is one we are actually sort of giving the body corporate the ability to make a say. There needed to be an economic reason behind that termination plan. Yep. And then effectively, if more than 75% of lot owners agreed to that, the body corporate then needed to go through a process to tell everyone about it, and people that didn't agree with the plan, the vote, or otherwise, then had rights to challenge that decision in the district court.
Yep, within 120 days.
Yep, absolutely. And so, and that then throws the onus back on the court, but there was more structure about it. And remembering, this is what QUT proposed. It is absolutely not what may or may not happen.
A bit of a summary of that, an article that we published at the time, that's just coming up there at the moment, which just goes into it in a slightly different way. So just to clarify, it's not a black and white 75%. There's a lot of detail involved around it. So I guess that then begs the question, Frank, what do we think will happen? We're not at liberty to sort of talk in any detail about the process that's currently underway. Some fairly strict confidentiality requirements. What we do know, though,
other than the fact there is a process, there is a discussion underway because it was an election commitment.
It was.
So government's made very clear they're going to follow through on those, and that's what we're talking about. So,
but what we can say, though, is that this is a super, super sensitive issue politically for a government. And why is that? Well, I think it's fair to say that no government, and certainly no minister, wants to be the one who ends up on the front page of the Courier Mail when Doris from Lot 1 is being turfed out of the lot she's lived in for the last 50 years because everybody else has forced her out because they want to terminate. Now, we all know that that's not likely to be the case, given what we've just described and the process around it, but it's the optics, isn't it, Frank?
It is. And I know, I suppose, one of my very first little bits of proper media, as opposed to, I suppose, self-promoted media like this is, on the news type thing, this pops up regularly. It has popped up regularly. Every couple of years, there'll be some talk about it, and away we go again. And I remember the phrase at the time being used was, it's un-Australian to force people out of their homes. And I do know I had a presentation with a former Attorney General in relation to a body corporate issue at one stage. We're doing sort of road shows, and I asked him about this and where they're at and all that sort of stuff. And his view was exactly that. I don't want to be on the front page of the Courier Mail, so I'd prefer to kick it into the long grass. But the time is coming where that can't continue to happen by virtue of the nature of the ageing of the buildings that we've got in strata, particularly in those coastal communities.
That's right. And also, Frank, I think it's fair to say that on the flip side of that scenario we just described about poor Doris in Lot 1 being turfed out, you've got quite legitimate interests, as you just spoke about there, where you've got a situation with a building that is in a lot of trouble financially and structurally, and to keep pouring money into it from a lot owner's perspective is just not viable anymore. So that you've got a lot of interest out there to move to a form of termination that's just a bit more achievable. So the question then for government is, how do they balance those competing interests?
It's a little bit ideological, isn't it? It's this private property ownership piece which you can't be disturbed with versus the will of the majority. And we see that all the time in body corporate in terms of bylaws, in terms of even you come back to there not being unreasonable interference with other people's use and enjoyment of their lot, which implies that there is capable of being reasonable interference.
That's right.
So that's at a much lower level, of course. But ultimately, and this is the holdout issue, if 40 lots and 39 people want to go and one doesn't, why should one be able to hold up the will of the other 39 when effectively you are in some form of collective enterprise? It's a really interesting one. I'm glad I'm not the decision maker.
Yeah, and this is why it is so difficult to get any kind of change or outcome on it, because it is such a challenging issue for government. So anyway, be that as it may, what are the takeaways out of this? Well, from the lot owner's perspective, if there is any suggestion whatsoever of termination, and I think we're talking there about legitimate as opposed to threat or whatever, Frank, but if there is any suggestion whatsoever of termination, seek advice. Don't delay on that one, because it's going to be one of the most significant decisions that you'll be involved in. So that's point one. And remember, at this point, if you're a lot owner and you're feeling a bit pressured by this, all that needs to happen at this point is that you vote no.
Or you don't agree to sell.
Yeah.
And even that sort of the conference I had with that client, we're running through some of the things that are now likely to happen. in terms of what the developer may do to try to bring pressure to bear about bringing people to tables. So it's a really interesting strategic exercise.
Well, that's the next point I think we were going to raise. So those points we just raised them were kind of on the don't want to sell. But then if you are a lot owner and you're actually quite keen to sell, what then? So the very first thing, unsurprisingly, Frank, is communication. Start the conversation with other owners. Is there a shared interest? Are there concerns? Can those concerns be addressed? You need to get the temperature. So again, we'll go back to your example, Frank, of the 40-lot scheme looking to be potentially redeveloped. You've had a great offer from the developer and you're fine to move on. You're not particularly wedded and you in a state of life where you're fine to do that. Well and good. You need to then start asking around, because if it goes down that path, you'll want to make sure that you've shored up support. You don't wait for the meeting for that.
Or you decide you're going to go on your own and not participate in the body corporate, make the developer come after you. And this has been an interesting thing this cycle with a few of these we've seen. And pre-GFC, developers were going and headhunting people individually. What I've definitely seen on a couple of these ones this time is the developers come into the body corporate, say, I'm happy to do a deal, but you guys have to go and herd the cats. I'm not going to go and chase 20 individual owners and try to bring them all to a table. It's a you problem to figure out, otherwise I'll move on to the next project. And so it's an interesting psychological thing, that one.
Very, and this is a good moment to remind everybody that lobbying in a body corporate is perfectly okay. And indeed, there are certain firms that can do that job for you if you ask them nicely. But no, in all seriousness, it's like anything else in a body corporate. If there is an outcome that you want, or indeed an outcome that you don't want in your body corporate, which is subject to a vote, there are ways and means to communicate, shore up numbers, lobby support, get interest for all of that kind of stuff. So then if you're an owner or indeed a body corporate and you're or a developer for that matter, hello to all the developers watching, and you're annoyed that the laws have not been changed for whatever reason, and you're concerned that they never will, time is now for you to get involved, isn't it, Frank?
It is, and you've actually got a government that is asking for feedback and input because they are going to potentially introduce new legislation about this or amendments to the legislation. So if you ever want to have your say, as opposed to just sort of throwing a submission in and hoping at some stage they look at it, because they're definitely going to do something. And that something might be nothing, but they have said, we're engaging, talk to us, which is what the working group's all about.
And you might not get what you want, but you've got to be in it to win it. And my view, and I've said this in a few forums, I'm sure people won't like me saying it, but if you don't have a say, then as far as I'm concerned, you lose the right to complain about it afterwards. So if you don't voice your concern or your interest, that's it. You've lost your opportunity to complain about it, I think. And I reckon, look, the sum up here is that, look, when it comes to termination, you've got to really take a step back, pause, reflect. And I think, Frank, this really emphasises the point that you and I make in these webinars all the time. These are decisions that must be based on something other than emotion.
And I think it is appropriate at times for the body corporate committee to take a leadership decision, a leadership position in these things, subject to how the developer's approaching it, what the opportunity is, and all that sort of thing. And it might be that a building decides it's going to put itself up for sale. So in that sense, the committee take a leadership role and herd the owners and bring it together, and maybe the owners will commit to one of those agreements we were talking about before, which gives people certainty around the fact that they're going to sell, because absolutely every developer out there is going to have been let down by someone somewhere who didn't sign when they said they were going to, and the developer spun their wheels. So you're a lot more attractive proposition as a body corporate if you're in control of what's going on and I suppose proactively managing the disposal process if the time has come to move on, that letting people chase you.
And yeah, again, can't emphasise enough, don't just go off blindly fumbling on this sort of thing. Get some advice on it. Tina, question. Thank you, Tina. I'm glad in particular you're watching today. Tina, am I reading correctly that there must be also agreement from tenants as well as owners?
The way, bloody good question, but I'd say registrable and short lease really only apply to commercial type leases. So if you're in a commercial premises, you've got someone in there with a 10-year lease, then absolutely they're going to be part of the program as a registered proprietor because they're registered on the property. And a short lease is one that, in commercial terms, is one that's under 3 years. That's not going to be residential tenancies though. So, and residential tenancies have protection under the Residential Tenancies Act. And of course, those leases usually only last 6-12 months. But it will be interesting when, assuming the government does produce some legislation on this, in terms of whether there's any rights to remove people from properties after a period of time, you know, whether they get engaged with as part of the process or whether there's forced evictions or something like that, which you got to say is a little bit lesser than forcing someone to sell a property that they reside in that they don't want to be there. So if anyway, it'll be interesting.
I'm pretty sure at this point that hasn't really been considered in any depth, the residential tenancies aspect to it. Thanks, Tina, and thanks for the suggestion too. That is it. Another compelling webinar. No, but seriously, it's a big topic, that one, and I hope people watching it have had a few anxieties soothed from what we had said today. But next week, speaking of anxiety, one of the most anxiety-inducing topics that you can deal with in a body corporate, certainly I used to all the time in Commissioner's office, we deal with it now, Frank, body corporate records. And we might even try a bit of another myth-busting exercise on this one. And so what I'd say to people watching this, if you've got a question about records, fire it on in. We'll try and get to as many of those as we can next week. I expect that there are lots and lots and lots. But for now, we've reached the end. That's the theme of today, so we've reached the end. Frank, as always, thank you.
Thanks, mate. Thank you, everyone, for joining us yet again.
Thanks, everyone. Really appreciate it.